Vindication for two bankers. How Britain's legal system handles LIBOR cases. A controversial verdict. The case of two bankers and the legal system in Britain. Were Tom Hayes and Carlo Palombo truly guilty, or were they simply victims of their profession as bankers? In 2015, Tom Hayes, who previously worked at UBS and Citigroup, faced conviction for his role in a conspiracy to manipulate LIBOR, which is a crucial benchmark interest rate used globally. His punishment was severe, with an initial sentence of 14 years in prison, equivalent to the maximum penalty for blackmail. Fast forward to 2019, Carlo Palombo, a former employee of Barclays, was sentenced to 4 years for his involvement in manipulating EURIBOR, another significant benchmark. Remarkably, both men regained their freedom in 2021. This situation raises profound questions about the integrity of Britain's legal system and its treatment of financial professionals. Are these sentences reflective of the crimes committed, or do they highlight a broader issue within the financial sector? But here's where it gets controversial. The harsh penalties imposed on these bankers have sparked a debate about whether the legal system is disproportionately targeting individuals in the finance industry. Critics argue that the legal repercussions faced by Hayes and Palombo may not align with the nature of their offenses, suggesting that the system is perhaps more punitive towards bankers than towards other professions. As we delve deeper into this topic, it's essential to consider the implications of such convictions on the banking industry and the message it sends to future financial professionals. Are we discouraging innovation and risk-taking in finance by imposing such severe penalties? And this is the part most people miss. The broader societal impact of these legal decisions could lead to a chilling effect on the banking sector, where fear of prosecution may stifle legitimate business practices. What do you think? Is the legal system right to impose such heavy sentences on bankers? Or is it time to reevaluate how we approach financial crimes? Join the conversation and share your thoughts in the comments. 4 traders appeal rate-rigging convictions after Supreme Court ruling. Imagine being convicted of a crime that others have just been cleared of. A crime that some argue was never really a crime at all. That's the reality for 4 traders now fighting to overturn their rate-rigging convictions after a groundbreaking Supreme Court ruling. Just 1 day ago, the financial world was shaken when the Supreme Court quashed the convictions of traders Tom Hayes and Carlo Palombo, leaving many to wonder, who else might walk free? And here's where it gets even more intriguing. Jay Merchant, Jonathan Matthew, Philippe Mariusef, and Christian Bitar are now stepping forward, demanding their names be cleared too. These traders were originally found guilty of manipulating LIBOR, the London Interbank Offered Rate, a benchmark interest rate used for loans between banks. This issue was at the heart of the 2008 financial crisis, where banks were accused of artificially inflating or lowering rates to profit or hide their financial troubles. But here's the part most people miss. The Supreme Court's decision to overturn Hayes and Palombo's convictions has opened the door for others to challenge their own cases, arguing they were unfairly targeted for practices that were, at the time, considered standard in the industry. Following the Supreme Court's landmark decision yesterday, all 4 of our clients now intend to appeal against their convictions. Stated law firm Hickman & Rose, representing the traders, they added, in these circumstances, they don't intend to comment further at this time. This move comes after years of legal battles, with Hayes and Palombo arguing they were wrongly prosecuted to appease public outrage over a financial crisis. But here's where it gets controversial. Was the entire LIBOR scandal a scapegoating exercise? Some argue that traders like Hayes, Palombo, and now these 4 were made into villains to distract from systemic failures in the banking system. The Serious Fraud Office, SFO, which led the original investigations, has declined to comment on the new appeals. However, in response to the Hayes and Palombo ruling, the SFO stated it had considered this judgment carefully and determined it would not be in the public interest to seek a retrial. The LIBOR scandal first came to light in 2012, exposing how banks manipulated rates for profit or to mask their financial struggles during the crisis. Fast forward to 2023, and the BBC uncovered evidence of an even larger state-led rigging of interest rates, allegedly under pressure from central banks and governments during the financial meltdown. This raises a critical question. Were individual traders unfairly blamed for actions that were part of a much bigger systemic problem? For the 4 traders now appealing, the process is likely to be smoother than it was for Hayes and Palombo, who fought their cases for years. But the broader implications of these appeals could reshape how we view financial accountability. Were these traders simply following industry norms, or were they crossing ethical lines? And more importantly, who should truly bear the blame for the 2008 crisis? As this story unfolds, one thing is clear. The line between guilt and innocence in the financial world is blurrier than ever. What do you think? Were these traders unfairly targeted, or did they deserve their convictions? Let's hear your thoughts in the comments. This is a debate that's far from over.